Lesson 4 begins again with a counseling component. Hopefully in Lesson 1 you were able to make some introduction and share some of your own career journey with the students to help them understand that it's not necessarily a straight line path to get to becoming a lawyer. But in Lesson 4 in the beginning, we take some time to let the students interview us in a more in-depth basis. There are some sample questions in the student handouts that the students may use to prompt discussion with you and learn more about you. Obviously, you don't need to answer any questions that are too personal, but this is an opportunity for students to have a positive experience talking with someone who has made it all the way through college and professional school about the realities and opportunities that are there to help get them where they want to go.
The topic of lesson number 4 is search and seizure. And again, a lesson we've used in the past, and again, I must say, it has been highly, highly popular. The students are actually disappointed when the bell rings and the class is over. I'm sure you'll find the same experience. And part of that's because of the way it's presented. Once again, they're put in the role of giving a fact situation and then told what the law is. And we take a look at the Fourth Amendment and a little bit of its history, but also take a look at all of the exceptions that do exist for when you actually don't need a search warrant. So we start with what is a search warrant? They're presented with one to look at. What are the criteria to get a search warrant? But also, what are all those exceptions for a search warrant requirement? Why do they exist? And then we present them with a fact scenario that they have to decide. You are the judge, and you have to decide, given the fact scenario, will I consent to, as a judge, that search warrant? And basically, the issue is there sufficient probable cause? Something that's not defined in the Fourth Amendment. And what are the facts that you look to as a judge to decide whether or not to issue a search warrant? This scenario happens to involve some very suspicious activity pertaining to possible counterfeiting. And someone with information and then other things that police officers saw, that were observed, and you have to make the decision. We also talk about the exclusionary rule, what happens when police gather evidence and it was in violation of the law, and the use or non-use of that evidence, which again is a really hot button topic, but at least they will know what it is and they will have some idea as to how they feel about it because of the discussion of it in the context of this case. We'll also be spending some time talking about, as one of those exceptions, the very famous case of Terry versus Ohio. And the really interesting thing about Terry versus Ohio is that it happened right here in Cleveland. As a matter of fact, it took place at Playhouse Square, and there's a marker there, and it was argued by one of the icons of our legal community, and that was Louis Stokes. He argued it from the get-go all the way to the U.S. Supreme Court arguing and representing the defendant in that case. So that's a nice local twist. Mapp versus Ohio also took place here in Cleveland, which is another case that we talk about that has to do with the exclusionary rule. So a real relevant lesson to the lives of our students because they all will know or know of someone who's been in a situation where they've been stopped and possibly frisked or been confronted by the police. And so this provides some very, I think, a real solid analysis of the Fourth Amendment and how it might apply in a given situation.